Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time that you actually need. And remember that if the panel has additional questions past the time you've been allotted, we will ask them and you'll have a chance to answer. We've read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know who you represent and how much time you are requesting. People versus Corey King. Five and 2 and 4. Ramirez versus 34.10 Development. I'm not sure you have an opponent. Do you want to be heard anyway, counsel? Give you a couple minutes? Sure. Okay, we'll give you 2 minutes. Mohammed versus Shanice. Submitted. Smith versus City of New York. I'll give you 5 and 2 and 5. RL Capital Partners v. HFC.
Appellant 5 and 2.
5 and 2 and 5. I am recused on that case. People v. Calvin Lilly. Submitted. AL Infinity v. Innovative Concepts. It's not the first time you've been here. Okay, and how about you? Okay, 5 and 2 and 5 and 2. Thank you. Bonia versus Vasser.
Daniel Heyman for defendant respondent Vasser Realty. 6 minutes, Your Honor.
Daniel Heyman for plaintiff appellant 4 and 2, please, Your Honor.
Okay, I'll give you 4 and 2 and 5. Polymet Trading versus Traxxas, North America. Counsel? You're asking for 5 as well? I'm sorry, what did you ask for? Okay. 5 and 2 and 5. People versus Amidou Dallo. Submitted. Kavano v. 237 Park owner. How much? 2 and 1. 2 and 1, okay.
Respondent, third-party defendant, Oran, 4 minutes. Plaintiff respondent, 3 minutes, please.
2 and 1, 4 and 3. Thank you. Chopa v. ESRT 112th West 134th. West.
Appellant 5 and 2. Defendant respondent 5.
5 and 2 and 5. Right, correct. Very well. Legal Aid Society versus Records Access Officer. I'm going to give you 6 and 2 and 6. Fatih versus City of New York. Submitted. People v. Kevin R. Would you like to be heard? There's no opponent. 2 minutes. Ogando versus 40X owner is submitted. Oh, excuse me. Yes. Ogando versus 40X owner is submitted. Marcus v. Marcus is submitted. Okay, first case up. People v. King. Please.
Jennifer Blasser, Office of the Appellate Defender for Mr. Corey King. Good afternoon. I would like to address 2 points today. The convictions in Queens County, which were obtained in violation of Mr. King's constitutional rights and were used to find him a mandatory persistent, for which he is now facing a life sentence.
Did the defendant ever express confusion about what he was pleading to with respect to the Queens SCIs?
The record indicates some level of confusion. Yes, Judge.
Can you cite his chapter and verse? I don't want to cut in too much to your argument time, counsel, but if you have a particular colloquy aspect of it that you want to tell us about.
Well, it's an overall sentiment from the allocution. I would like to say that over the course of only 7 pages, the court in Queens both goes through 4 different SCIs, 4 different pleas, and a predicate statement. And it seems from Mr. King's responses that he is just saying yes to each of the things he is waiving and then to the plea. But again, at the end, the court then asked for a 390 examination, which I think is an indication of the confusion that was happening at the time.
How do you distinguish the case from Lang?
Yes, Judge Lang was in a different procedural posture. Lang was about whether the omissions in the waiver of indictment were such that they rose to a jurisdictional defect. What we're saying here, this is distinguishable from Lang, because what Lang said was that only the waiver of indictment had the omissions. In this case, it's not just the waiver of indictment. It's the waiver of indictment and a very, very, very bare-bone SCI that doesn't have the approximate time, that only states Queens, and that coupled with the allocution, it shows a tremendous level of confusion.
But what about the felony complaints that do give chapter and verse?
The felony,
The felony
yes.
complaints, all the so-called omissions in the SCIs were clearly addressed in the felony complaints in terms of breaking down time, places, victim, manner of the crime, et cetera. So the whole focus of all this is notice to give you due process to avoid double jeopardy.
Yes.
So when you take that together with all the accusatory instruments in toto, doesn't that resolve that notice issue?
Well, in Lang, the court makes clear that what gave Mr. Lang notice was the combination of the accusatory instruments, both the complaint and the SCI. And the SCI had sufficient details to give the defendant notice. Here, while the complaint had those details, the SCI definitely did not.
Where does it rise to a constitutional level versus just statutory, like it didn't meet the statute? What is your basis to suggest that his constitutional rights were violated?
Well, I think that the whole process is meant to safeguard the due process rights of a defendant who in that moment is waiving significant rights to be prosecuted by a Supreme Court information instead of a grand jury. And in this case, the record is clear that he did not receive, that Mr. King did not receive sufficient notice.
But that's not so, because the felony complaint gave him sufficient notice, and why isn't that good enough?
Because again, I think what Lang makes clear, Judge, is that it wasn't just the felony complaint that provided the defendant there with notice. It was the fact that the SCI had all those details as well. The SCI that was filed contemporaneous with the waiver of indictment and was able to provide the defendant with notice.
But when you have the information that whatever defect there may have been in the SCI, it's not pursuant to Lang a jurisdictional defect when you consider the information that he had from other documents.
Yes, but I do believe that given the omissions in the waiver of indictment, which were time, place, and location, and then an SCI that is very bare bones, those documents together, even with the accusatory instrument, the complaint, just simply do not provide, Mr. King did not provide him at the time with sufficient notice. And then you add the fact that the SCI, in one SCI, the name of the complainant, I see my time is
Please finish.
in the SCI, in one of the SCIs, the name of the complainant is different in the SCI than it is in the complaint, than it is in the allocution. In the second SCI, it's the same name in the complaint and the SCI, but then different in the allocution again.
This name discrepancy wasn't raised before, right?
It was not raised
So
before.
it's not preserved.
Your Honor, I see that I'm out of
You
time.
can, you can attend to that on rebuttal.
If I may address the sentencing on rebuttal.
Very good.
Thank
you.
Good afternoon, Your Honors. May it please the Court. Christian Rose for the people. I'd like to start with two clarifications. The first is that there's no indication of any confusion at the 2013 convictions. The defendant is simply saying yes in response to questions, but he also says more. The court asked questions about...
Also, how do you respond to the adversary's position with regards to the victim names and the discrepancies?
Sure. So there's also no question that the defendant was fully aware of the charges against him. So fundamentally, the felony complaint and the other charging documents make clear that what the charge conduct was. This court and Lang have held that variances and
I want you to address the
non-elemental...
name specifically,
Right.
though, however, 'cause that could be confusing.
Well, variances and non-elemental factual information, like victims' names, for example, do not rise to a constitutional error unless, if looking at the record as a whole, it's clear that the defendant didn't have notice of the charges against him. And the Court of Appeals has said in Milton that when the felony complaint, the SCI, the waiver of indictment all cross-reference each other, as they do here, there's really no risk of confusion. And so just based on that alone, there's really nothing else. And it's exactly the situation where the defendant needs to object if he's actually confused about some victims' names.
When you say that they cross-reference each other, is that the SCI mentions the docket number in each of the felony complaints in the underlying criminal court matter?
That's right, and even more than that. So each SCI lists the docket number, but then the court, I believe, also went back and wrote the SCI number on the corresponding felony complaint, and then the waiver of indictment also includes those numbers. So it's very clear. It's like a matching game, right? They all reference each other. It's clear what's being charged. If I can just briefly return to the 2013 plea colloquy, I would say also that the defendant is making intelligent answers where the court goes through the factual elements of a crime, and he interrupts the court to say, what are you talking about, a participant? There is no participant. I did it. I think that's not evidence of somebody who's being confused about what's being charged against them. And I'll also just note that a 390 is a pre-sentence report. It's required by law. That's not a mental competency examination. As for the excessive sentence claim, I'll just say that this court should not reduce a sentence that's already about 10 years unlawfully low, which he earned after assaulting 2 corrections officers on separate occasions while serving the 10-year prison sentence against, or for the 4 armed robberies. If there are no other questions, we ask that Your Honors affirm.
Thank you.
The cases before this court were at a time where Mr. King's mental health was at its all-time peak. He was 730 twice and found unfit.
Counsel, bring the microphone a little closer.
I'm sorry.
Thank you.
He was 730 twice and found unfit during the pendency of these cases. He has a well-documented history of psychiatric history. He is finally correctly medicated. He is finally with a correct diagnosis. He is, however, serving a sentence of 14 to life. We believe that this court has the authority to look at the facts before it now and consider the minimum sentence of 12 to life, given the circumstances and the fact that Mr. King faced this sentence when clearly under extreme paranoid delusion and extreme mental illness. Thank you.
Thank you, counsel. Thank you both. Okay, we'll hear from counsel on Ramirez. Please.
Good afternoon. Yes, this is obviously an appeal from a decision by Judge
Counsel,
Guest.
state your name again and who you represent.
I'm sorry?
State your name again and who you
I'm
represent.
sorry. Michael Manorel for the appellant, defendant, third-party plaintiffs, 3410 Development LLC and Atria Builders LLC. This lawsuit arose out of a construction accident. The parties were building a Marriott, a Courtyard by Marriott hotel. 3410 was the owner of the building, and Atria was the general contractor. Executive Group, one of the third-party defendants, signs a contract with a subcontract with
Counsel, isn't it crucial that they also describe themselves as a DBA in their answer?
Absolutely. I mean,
That's kind of a slam dunk for you, isn't it?
I would say that should be dispositive of the whole thing. That was one of their main points of their argument, is that how can we say that they're the same entity? We don't present any proof. We never did any discovery on that because they answered Executive Trim Construction, DBA Executive Group. So, there was no one deemed it necessary to proceed with discovery on that. In this case, Executive Group entered into the contract with Atria. Under the Atria Executive Group subcontract, Executive Group agreed to store, deliver, and install furniture, fixtures, and equipment at the project, the hotel project. Plaintiff's accident happened while he was installing furniture and fixtures at the project. Clearly, plaintiff's work was within the purview of the Executive Group subcontract. It makes no difference that he had appeared for Executive Trim. I see my lights up. If I can just make one or two quick points. Whether the entities are separate entities or the same entity doesn't matter, because Executive Group was obligated under the contract to do the work and to indemnify. If
No,
they
you do
signed
make
it,
that point in
someone
your
else-
papers. Yeah, very well. Thank you.
Okay, and then one
That's
other-
it, Counsel. Thanks very much.
Okay, thank you.
Okay, Smith v. City of New York. Please.
Good afternoon, Your Honors. May it please the Court. Amy McCampbell on behalf of the City of New York. Your Honors, this Court should reverse and dismiss the complaint because it is barred by the plain language of the general release that Smith signed. The general release could not be...
General release, when that general release was produced and given over to the other side, it contained the reference number pertaining to action number 2, correct?
At the beginning, it identifies Smith as the signatory in the context of the settlement of that case, and this Court has already addressed that...
Is there anything in that release that would that incorporates or mentions or references action 1?
Only in the context of identifying Smith as the signatory, and that is in the context of settling this case. And this Court has directly addressed that point in the Ortiz versus City of New York case, which this Court held that that kind of language at the top of the release that identifies the signatory is only in the context of identifying the releaser, and it doesn't serve to limit the scope of the general release. The scope of the general release, again, the language is very plain and it's unambiguous, that it applies to any claim that Smith had as of the date of signing against the City of New York, unless he expressly chooses to exclude them. And the language
You
saying...
also asked for the excluded cases to be listed, right?
Yes, Your Honor, and that language instructing Smith to list any cases he wished to exclude is in boldface, all caps, plain as day.
Does it matter that the email that was sent to plaintiff's counsel, in essence, stated that it was only being sent, the settlement only pertained to action 2?
2 points in response to that, Your Honor. First of all, the settlement negotiation emails, they don't come into consideration because they're extrinsic evidence, and we only look at the plain language of the contract because it's clear and unambiguous. And I'd point the Court to the Donahue case from the Court of Appeals, and also this Court's decision, Bernard versus Sayedge, which applies that in the context of a general release. But even if you look at the evidence, the extrinsic evidence, the settlement negotiations, all it shows was that this general release was signed in the context of settling one particular claim. And that's exactly what the Second Circuit recognized, looking at the exact same type of evidence in the Mateo case, which we cited. The language about this email only pertains to settlement of this claim. The full context says, this email relates only to settlement of the above subject matter. Do not use the attached documents for any other settlement. And that makes sense because the city uses these form documents all the time, and we're always updating our form documents. So this makes clear that the plaintiff has to use the documents attached to this email and no other prior versions of those documents. So again, even if you look at the extrinsic evidence, which we shouldn't under Donahue and under Bernard versus Sayage, all it shows is that this general release was signed in the context of this particular settlement. There's nothing in the record to show that the parties intended to limit the scope of the general release to exclude this claim. And in fact, Smith had the opportunity to do so by listing it in that space. He didn't write anything there. Instead, he signed the general release. In signing it, he affirmed that he read and fully understood it, and his lawyer notarized the general release.
Does it matter that same email, which referenced many documents, stated that make sure that the caption matches the caption of the latest, most recent summons on file with the court, pertaining to action number 2? And nowhere does it mention action number 1.
That's right, Your Honor, because all those documents were signed in the context of settling that case. But the general release is a separate document that's part of those settlement negotiations that specifies that it releases the city from all claims that exist as of the date of the release. And Smith's attorney was well aware of the general release. When he sent back the settlement papers, and this is 283 of the record, the first attachment is 2 original copies of the general release. So he was very well aware of it. That Smith's appellate brief mentions that the city uses these general releases routinely, I think is the word he uses, systematically. So this was a well-known practice. Smith had the opportunity to exclude this claim, and he did not do so.
Would it change? Would the result here change if plaintiff had separate counsel on each case, and the counsel for action number 2 had no idea that he had an action number 1 pending somewhere?
You know, Your Honor, that might be a different case. I think that was the case that happened in the Saddam case, which was a trial court decision that Smith is citing, but that's certainly not the case here. Here, he had the same counsel on both cases. They were both false arrest claims against the city from different arrests in the same month of the same year, and Smith did not write the name of the second action on the line to exclude it from the scope of the general release. And for these reasons, Your Honor, we ask this court to reverse and dismiss the complaint.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent. I wanted to
Mr.
bring
Isaac,
you-
why isn't the release just the whole ball of wax? We don't look at extrinsic evidence if it's so clear.
It's not clear. That's why. And I'll tell you the case, your case.
I thought you'd have a case like that.
Well, I'm at First Department, of course. Herman against Melliman. This court found that courts interpreting releases, I'm quoting now, it's 107 AD 2nd 575 577, often hold that the general words of a release are limited to the recital of the particular claim. Thus, if from the language of the instrument it appears that the release is to be limited to certain claims, demands, and other obligations, then the release will be operative as to those matters only. The Third and the Fourth Department, looking at that case, held in Camperlino and Green against Lake Placid, and I'm quoting, this isn't Brian Isaac, where the release contains specific recitals as to the claims being released, and yet contains 3 dots, an omnibus clause, which is exactly what we have here, to the effect that the release or releases and discharges all claims and demands whatsoever he may have against the releasee. Courts have often applied the rule of justum generis and held that the general words of the release are limited by the recitals of a particular claim. That applies here in spades. And I wanted to point out to you that the city's making, Your Honors, you asked some questions about it. They're not making any bones about what happened. Reply brief, page 7, sentence 3. Again, this is not Brian Isaac. This is the city. Beautifully written brief. This is what they said. I'm quoting. Rather, that the parties engaged in discussions in connections with only the second false arrest action made perfect sense, colon. That was the action the parties had elected to settle. That's the city's brief. So what they're saying is that a technical mistake that was made by an attorney with respect to not carving out a claim wipes out a claim that was never intended to be settled There was nothing there to be settled. As the court pointed out on page 278 of the record, there's a big bold-faced type which says, use this only to settle this claim. Every single settlement document has an index number, the name of the case, a city number, a law department
Mr.
number.
Isaacs, we understand that we document things carefully with index numbers and case numbers, but general releases, this isn't our first rodeo, both as practitioners
Sure, it's not.
and as judges. And you know that if you were doing a general release for your client and you wanted to carve out an exception to that release, notwithstanding well-settled case law as to the effect of a general release, going all the way back to the beginning of time, to the point and date of the release, that intend to release anything and everything up to that point in time. And if there was an exception, Mr. Isaacs, I know if you had gotten this document, you would have written something down on behalf of your client. And that bold language makes it very clear that if nothing is written below the line of that big, bold paragraph that's unambiguous, then it means all is forgiven. Yes or no?
If you think I'm going to stand up here and tell you that 2 and 2 equals 4.5 or 5, I'm not going to do it. We should have carved it out. We didn't. It's a mistake. I would ask you to look at matter of Frutiger, which is a case that we cited with the Court of Appeals at 29 New York 2nd. The Court of Appeals specifically held that even unilateral mistakes, this is clearly a unilateral mistake, even the city says it is, can be corrected when the parties can be restored to the status quo ante. I would also ask you to look at 3 Court of Appeals decisions, which I know you know, and I'm not going to go over my time. Cahill against Regan, it's 5 New York 2nd, 292. Mangini against McClurg, it's 24 New York 2nd, 556. And Best against Utaka. Best against Utaka was a reversal by the Court of Appeals where there was a general omnibus clause, and the Court of Appeals said even though there was a general omnibus clause, based on the circumstances of the case, it was unlikely that the plaintiff meant to settle a personal injury case when the consideration, and we know what the consideration is here, it's not for the other case, showed that it was a property damage claim. So I agree with you. I would never tell you I would never tell you a mistake wasn't made. It was. But courts of justice exist for a purpose of securing a fair resolution of controversies on the merit. Again, not Brian Isaac, Nicholas against Rosenthal, your decision from 1953, and this just isn't fair. They took advantage of a mistake. They shouldn't be allowed to do it. The trial judge was correct in his ruling, and you should affirm it. Thanks for listening to me.
Your Honors, a few quick points. So Smith is seeking to rely on case law that says that when a release contains specific recitals as to the claims being released and the general release is interpreted according to that language. Here, this claim was not listed in the recitals. Again, it was listed at the top of the claim identifying the signatory, and this court in the Ortiz case made very clear that when the plaintiff's name is only identified in the context of identifying the signatory, that's not the same as in the recitals. Second, plaintiff just admitted he made a mistake. It's very, very, very clear that even if a party makes a mistake in signing a contract, the party is bound by the plain language of the contract. I'd point this court to the Henry Schaefer case from the Court of Appeals and also the Barclay Arms case. So unilateral mistake in the absence of fraud or other showing that is along similar lines, which they've never argued, no basis to invalidate a contract. Third, I heard plaintiff just list a bunch of cases. I had a hard time catching them all, but all of those cases are distinguishable. The Best versus Utaka case, part of the issue there was the parties continued to litigate the case for 2.5 years. Here, the release was signed in May, and the city moved to dismiss on the basis of the release in the other case in October. So you don't have that same kind of delay. So all of the cases that the plaintiff is seeking to rely upon are distinguishable. And again, this court should follow its own precedent in Ortiz and the Bernard versus Sage case and find that the plain language of the general release is controlling and that this case must be dismissed.
Thank you. Thank you both.
Thank you.
The next case is RL Capital Partners. I am recused in this case. Justice Friedman will preside ably.
Good afternoon, Your Honors. Kevin Nash for the appellant. We are appealing a ruling dismissing a renewed action under 3211. Case arises under the New York debtor and creditor law. And
Sir, we read through this carefully, and I'm still struggling, as I know the court below was struggling. Outside of the organizational chart and an email by a JPM employee to direct that certain proceeds of the refinancing be set aside to pay off an antecedent debt that was legitimate, where on this record is a fact that suggests that JPM had knowledge of the agreement between AREL and HFZ that made them a Class B member to be entitled to first dibs for any kind of net proceeds towards their investment? Where on this record? I'm looking for it. Show it to me.
When Your Honor says besides the organizational chart, I think it's important that you look at that organizational chart in its proper context. It clearly delineates AREL as a member of these four-pack properties.
That's it, though, right? It at most it identifies AREL as a member, but there's nothing about the agreement.
True, there's nothing about the agreement, but this is a situation where the surplus went outside of the four-pack into another transaction called the XI. So you have knowledge, you do have knowledge of the AREL interest, and I believe that there was a duty of inquiry, given you have knowledge, to make inquiries to whether or not it was properly permissible to take those monies, take them elsewhere, and violate the rights of AREL. Now, at this pleading stage, and that's where we are, I think I'm entitled, and this was a big focus of my brief, I think I'm entitled to every presumption, all reasonable inferences on those points. So I went back, the first action was dismissed. There was a challenge. Show me how Chase knew about AREL. The organizational chart, it's not one, it's 12. It's 12 organizational charts attached to every one of the loan agreements. And on top of that, you have...
Is it enough to know about that organizational chart, or did it had to know that AREL had priority to this $7 million plus?
Well, the simple question is, we see AREL. Let me see the operating agreement where AREL came into the transaction, and had they made that inquiry...
So JPM is sitting at this closing, and they've got another entity, XI, which is owed a lot of money. It's taking this money to pay off a debt duly owed to it. So the fact that they see this name AREL appearing on this chart imposed a duty upon them to find out, well, let's see.
I believe so, and I'll tell you why. This is not an ordinary refinance. This is $500 million refinancing. And this is a highly complex corporate refinancing. And every commercial lawyer, bank lawyer worth its salt will look at every operating agreement in connection with a $500 million refinancing. That didn't happen here. And you just can't presume out of hand that they are...
Well, that organizational chart doesn't yet give it notice, does it, of the operating agreement?
It certainly does. They're in play as one of the members of the entity. So members only become members through an operating agreement. Operating agreements need to be reviewed. So and we're talking about the good faith status, and that's only a defense to the actual fraud claim. There is also constructive fraud claims here as well.
I'm just curious. What is the percentage interest in this? Maybe I'm missing. I think on the record on page 776, 1.81, when the entities that were seeking the refinancing had a substantially greater percentage ownership interest, and were also responsible for the debt on the XI project.
True, but I think...
So when you see that, I mean, as my colleague pointed out, where is the red flag with your client having a very small interest, notwithstanding the operating agreement giving them first dibs? I'm not making light of the operating agreement.
Okay.
I'm trying to figure out why JPM, as a lender, bona fide lender in good faith, giving the $500 million, It's just asking for a certain percentage to pay off a legitimate debt.
Fair enough. Look at, and it's a good question, but look at the header of the organizational chart. It says WB portfolio structure chart after the Arel investment on the top of it. And then the third page of the chart in 750 gives you the corporate structure of Arel. So you have a whole page devoted to Arel, and you have a whole top header after the Arel investment.
Thank you.
You can't say, we can close our eyes to what Arel, how they got involved in here.
Thank you. You have time in response, so we'll hear.
Thank you.
Good afternoon. Shira Sandler from Fried Frank on behalf of the respondents, JP Morgan Chase Bank NA and JP Morgan Chase Commercial Mortgage-Backed Securities.
Counsel, so what do you say about that header?
That header, it tells us nothing. As we talked about, as you had acknowledged earlier, this org chart, even with the header, it only shows that Arel Capital has a 1.8% interest, and that's it. There's no reference to the operating agreement, there's no reference to appellant's rights, and that is just not enough under New York law. And appellant mentions that JP Morgan had an obligation to further inquire upon receiving this org chart into what rights appellant may have, but that is simply not the law in New York. There's no case law that shows that JP Morgan, as a good faith lender, has an obligation to inquire into appellant's existence. And the public policy considerations of that, if that were the case, would be staggering. It would mean that every commercial lender would have to spend hours and hours and hours doing due diligence to figure out what entities may have an interest in a 1.8% interest, what rights they may have, and that is just not what the law is.
Normally, when there's a situation of a fraudulent transfer of some kind, or under the debtor-creditor law, there's something missing. There's nothing missing here. This was real consideration.
That's exactly right, Your Honor. That's a great question. All that happened here is that JP Morgan and its borrower, the loan was refinanced, and its borrower who—
The money to which it was entitled. It was entitled to that money because of the XI transaction.
Correct, that's exactly right. And the borrower made a decision to pay down a legitimate debt on the 11, which again was a separate transaction, but that's no basis to impose any wrongdoing against JP Morgan. And that also, the $7.2 million that appellant claims it was deprived of is the subject of that first action that JP Morgan was dismissed from against HFZ Res, who's the entity that it actually entered into an agreement with and that it actually claims it was wronged by.
How far removed are the borrower and HFZ Res from each other?
So the structure chart is a little confusing. It's actually laid out in the record, but appellant has a 1.8% interest in HFZ Res. HFZ Res is a 50% member of HFZ Res portfolio member, which is the 100% member of CE HFZ NYC. And for each of the 4-pack properties, and again, only one is at issue here, HFZ NYC 100% owns an entity, which in turn 100% owns the SPE. So in short, it's over 5 tiers removed, and again, it only has a 1.8% interest. So I know that my light is on. Just want to wrap up a few points that were not addressed. While appellant claims that he's entitled to every possible favorable inference, and that is what CPLR 3211 does say, those inferences can only be taken from the complaint, and the complaint simply does not allege any knowledge or any wrongdoing on the part of JP Morgan. And another thing to point out that appellant entirely ignores in his papers is that the entity that made the transfer is the borrower, who they are not a creditor of. So there's just no basis for this fraudulent conveyance claim against JP Morgan.
Thank you.
Just two quick points, if I could respond. The question was it a legitimate debt of the 4-pack? It wasn't. The four-pack owed no obligations whatsoever on account of the XI debts. They weren't guarantors, and so it was outside of the four-pack. Those debts that were owed on the XI were not owed by any of the four-pack entities. So you have a situation where corporate monies are used for non-corporate purposes, and that creates the framework of the fraudulent conveyance action. So it was not legitimately funded. That money should have returned to the four-pack entities, and had they returned to the four-pack entities, then Arel has the first waterfall rights under that. That makes it a creditor because they didn't receive what they were entitled to after the refinancing was complete. On top of all of that, it was misrepresented, the status of the refinancing for many years. The judge found a breach of fiduciary duty.
That misrepresentation wasn't a part of J.P. Morgan, right?
True, but under the debtor and creditor law, the constructive fraudulent conveyance series, the defense there is fair consideration. One of the elements of fair consideration is mutual good faith of both the transferor and the transferee. Here we have the judge in the trial court saying transferor acted in bad faith, so that cuts off under 272 of the debtor and creditor law fair consideration. The court below just didn't take it to its next step, and the next step would have been that the constructive fraud claims survived no matter what. You might have a different view on the actual fraud. I hear from your questions you do, but the constructive fraud claims should survive because there's not mutual good faith, and we cited your case in Sardi's on that point. It's a key point. It's 2014 is the decision. This court said both the transferor and transferee have to operate in good faith, both of them. Otherwise, there's no fair consideration under 272.
Thank you. Thank you both.
Thank you.
AL Infinity versus Innovative.
Please.
Good afternoon, Your Honors. Jerry Grunsfeld for the appellant, and also we're the respondent on the cross appeal. There are three issues being appealed here on my client's appeal. The first is with respect to the first and the fourth causes of action, whether Gemini had the right to rescind the contract either because of fraudulent inducement of the renewal agreement or because of a material breach of the agreement. That's the first one. The second issue is whether the court was correct to grant the seventh cause of action where a plaintiff sought reimbursement.
Counsel, how do you reconcile what you're seeking here in terms of a reversal on summary judgment on liability while they have the cross appeal for damages on the first and fourth cause of action? How do you reconcile the two prior appeals where you lost?
Right. So they're completely different things. In the first case, the prior action, Gemini was the plaintiff and was seeking affirmative breach of contract claims and also a fraud claim. With respect to the fraud claim, for example, Gemini lost that because the court found that although they admitted the fraud, there was no damages because ultimately the fraud was discovered prior to any damages being sustained. And with respect to the breach of contract claim, the court found that the sole discretion clause prevented the breach of contract claim. But here, Gemini is the defendant and is asserting affirmative defenses. And some of these
that distinction means nothing to me. Well, claim preclusion, it applies when you could have raised these issues in a previous case, right?
Correct.
So you could have raised all these issues in the previous cases.
Your Honor, we couldn't have. How could we have, for example, raised an affirmative defense when we're the plaintiff. If they're, Your Honor, if they're arguing...
Call it a claim then, if you want to get involved with nomenclature. In other words, you could have raised it as a claim in the previous cases.
Your Honor, we couldn't because there would have been no damages as the plaintiff. Here, we're defending a breach of contract claim on the basis that they materially breached the contract. And the basis for it is a completely different factual underpinning. In this case, we're claiming that they, with respect to the fraudulent inducement, that they deliberately misled Gemini into re-signing the license agreement. Those facts had not, the facts underpinning that defense weren't known to my client at the time of the original claim. So it wouldn't have been possible for them to make that defense because the facts underpinning that defense weren't known to them. In addition...
You had the November 28th letter. You had the previous SACAR objections that were known to you. Why isn't that sufficient?
Because what we didn't know was that at the time the contract renewals were being renegotiated, Infinity contracted with SACAR and agreed to put these drastic restrictions against Gemini into the SACAR contract, but deliberately took actions to withhold it from Gemini. Gemini only found out that they had already put those...
Before you enter into the renewed licensing agreement, before your client entered, why not just clarify all of this before you commit yourself to this very detailed renewal of a license agreement?
Because Infinity took actions which were designed to deliberately mislead our client. They didn't think they needed to clarify it. They actively marketed the Expedition 4 on behalf of Gemini. Why would Gemini say, will we be allowed to continue selling the Expedition 4 when Infinity themselves are helping them sell the Expedition 4?
Yeah, but doesn't the sole discretion put you at risk that, say on day one, we're going to let you do X, Y, Z, and then on day 3, I mean, I'm not quite quoting the court below, she said lights are out, but
right.
Let's say they suddenly say, okay, we don't want you to do it, or change the dimensions, or whatever.
Right.
I mean, you're not unsophisticated here. You could have said, we just don't like this clause anymore. We felt it was like the sword of Damocles over our head.
Right.
Let's strike that out, or negotiate it. As my colleague pointed out, you could have resolved and added clarity to all this. But
Right.
you didn't. You signed it.
Your Honor, that's an argument that could be made with any fraudulent inducement agreement. One could always say to the defendant, why didn't you make sure that you wrote the contract better? At a minimum, it must be a question of fact, because otherwise what that would mean is that Infinity could have engaged in any length of deceit to get us to sign it, and then once we had signed it, they could have said, actually, Gemini, you know what? We're going to use our sole discretion clause, and from now on...
But the sole discretion clause, they exercised that clause way back, and you had an adverse, they took an adverse position to you. So you had information from way before you signed the renewal that they had already taken adverse action against you and the speaker. So that puts you on notice. So I don't know how you relied on anything that they said with regards to getting you to sign that renewal.
Your Honor, if I could just finish the point I was trying to make, that at a...
You should respond to Justice Rodriguez's question because you're out of time.
Yes, it's directly related. I believe if I could finish the point, it will answer...
Please, go ahead.
At a minimum, it must be a question of fact as to whether there was fraudulent inducement despite the sole discretion clause and despite the past experience, because if not, what that would mean is that Infinity could have taken any actions to deceive my client, and then the minute my client signed the renewal agreement, they could have said, you know what, we're using the sole discretion clause to decide that going forward, you can only sell neon orange speakers that are 1,000 feet long. Surely that would not be a valid exercise of the sole discretion, because then we would have, but you still have to pay the guaranteed minimum of $700,000 a year.
Thank you, counsel. You have time in rebuttal.
Thank you, Your Honor.
May it please the court, Elon Dobbs for plaintiff, respondent, appellant, Ale Infinity. I want to get to my cross appeal, but there's just one.
Well, why don't you pick up on the thread that your opponent left you with, which is, does the sole discretion clause allow your client to mislead Gemini about the resolution of the SACAR complaint?
It does not, but the alleged misleading was the subject of a motion to renew, which was denied by the lower court, which denial was affirmed by this court. Justices Rodriguez and Friedman were on that panel. Justice Schulman, I believe, was also on that panel. There were 2 motions to renew that were made in the lower court. Simultaneously with the motion to renew, Gemini moved to amend its answer and to assert counterclaims based on these identical frauds, alleged frauds. And they were denied. Those motions were denied because they would not have changed the outcome. And this court twice affirmed those denials of renewal. And the lower court denied the motions to amend to add counterclaims for fraud and breach of contract for the same reason. And those were not appealed and are no longer appealable until the entry of a final judgment.
So anyway, so you're here because you felt the lower court should have granted you damages as well as liability, correct?
That's absolutely
on your
true.
first and fourth cause of action, and on your well, I think the second cause of action was conceded, and the third cause of action for the cost for the electric show, the $100,000 was also a claim that you think should have been granted, because we're dealing with some certain there aren't real triable issues, correct?
That's correct. There are stipulated minimum damages by contract, and over and over again, courts in these types of contracts where there is a license and there's a stipulated minimum amount that the licensor is entitled to receive by contract, if there is a breach and the agreement is terminated, the licensor is entitled to the full amount without regard to mitigation. This court has said that the standard that the lower court applied, well, perhaps you received something later that the damages will be offset by, is without basis in law. You said that in the Addressing Systems and Products versus Friedman case, which we've cited in our briefs. And multiple federal courts, citing this court, citing Justice Freed's decision in Honeywell, which this court affirmed in its entirety, have held that once you determine that these clauses are reasonable, that the sums are reasonable, we're entitled to the full amount, and no hearing on what happened subsequently matters at all.
And is it your view that, notwithstanding your friend's contention, that this acceleration, creating the $960,000, for example, as a penalty, has no moment because the actual agreement provides that it is liquidated damages?
It provides that it is liquidated damages. It's also not a penalty because it represents the minimum amount that we stand to gain under the agreement, and 6% of a stipulated minimum sales figure. And over and over again, courts have, and we cited all of these cases in our brief, the federal courts have been very clear on this, applying New York law, citing to this court's jurisprudence, saying that similar percentages of minimum guaranteed payments are enforceable as written. And that's what the lower court should have done. With respect to the $100,000, we adduced, this is just a straight up summary judgment issue, we adduced in admissible form proof that there had been a negotiation, a discussion about the $100,000, 120. Well, the agreement said that they would have to pay $125,000. There was email correspondence saying, hey, you know what? You'll pay $100,000 on December 26th, 2019, just days before the show was to begin. They said, you know, we hereby cancel the agreement. We're not showing up. And we defaulted them for not paying $100,000. In opposition, they adduced no evidence at all. They said we were entitled to rescind the agreement, and later they've said, well, we actually didn't have to pay that $100,000 unless we showed up to CES. And the plain language of the agreement flatly contradicts that position. There's no real substance to it. And in making that argument, they cited to the superseded provision in the original license rather than to the one in the renewal, which makes very clear that attendance at CES is absolutely mandatory. I don't know if the court has any other questions. I'll reserve for my rebuttal.
Thank you, counsel.
With respect to the accelerated damages clause, it's a fundamental tenet of contract law that in order to obtain damages, you have to have sustained damages. And under the facts of this case, there were no damages because Infinity replaced Gemini with a superior licensee who...
You cite Van Duzer and a bunch of commercial lease cases for that proposition, right?
Right.
So, but in commercial lease, with commercial leases, one knows the rent that's going to be due and owing. You know, it's specified within the lease. Here, this is, I think, this is two parties trying to predict what, you know, would be fair liquidated damages because they don't know exactly how much he's going to, one party will be out of pocket. So I don't see the analogy between the commercial lease cases at all.
Your Honor, I would say two things in response to that. First, they do know the amount that's going to be due because that's what guaranteed minimum royalties are. That is the amount that is going to be due. So they do know. And the second thing is that I also cite about 7 different cases outside the context of a lease. There is tuition clauses, tuition agreements. Again, they know in tuition agreements, they know exactly how much would be due. And in that case as well, they found...
So, one thing I wanted to ask you about, you seem to imply in your reply brief that some limitation, some cap on the acceleration period would be permissible. So 12 to 18 months cap on the acceleration clause would be okay?
So one of the...
How do you make that distinguished? How do you make that point?
So one of the factors that determines whether it's a penalty clause or a liquidated damages clause is whether it's a reasonable estimate. And when you don't put any type of cap on the amount of the acceleration, even in the event of replacement with another licensee, that goes to show that it was never intended to be liquidated damages, but rather was going to be a penalty.
The cap, isn't the cap in the amount of sales? They capped it in the amount of sales. Those were the minimum sales that they expected you to make.
The reference to the cap would be if you terminate if the agreement is terminated early, you're going to be responsible for a minimum of, say, 18 months or the balance of the lease, unless a replacement licensee comes in, and then you'll only be then the penalties you'll have to pay will be capped at 18 months.
Thank you, counsel.
Because that would have been a fair estimate of how long it would take to replace them.
Thank you.
Unless the court has other questions, I have just a couple of brief points. One, in the commercial lease case, in the tuition cases, and in the other cases my adversary cites, the liquidated damages at issue represented the full contract price. In other words, the maximum amount of recovery that the lessor or the school could recover. The difference here in the licensing context is we estimate at the beginning, we say this is the minimum. This is the minimum benefit of the bargain that the licensor is giving this license for. We don't know what the maximum amount was going to be because we didn't know ex ante how much sales they were going to make. And in every single case that involved a license agreement and minimum royalties as a form of liquidated damages, that was deemed to be reasonable under circumstances materially identical to these. Unless the panel has anything further, I can rest on my briefs.
Thank you, counsel. Thank you both. Bonia versus Vasser. Please.
Good afternoon, Your Honors. May it please the Court, Dana Heights on behalf of Plaintiff Appellant Delania Bonia. On its motion, defendant was required to show that there was no dangerous condition and/or that it did not create or have notice of the condition and/or that the condition did not cause the plaintiff's injuries. Defendant did not show one of these things. Defendant claimed that the accident didn't happen in exactly the way the plaintiff testified it happened because the door in question didn't physically contact her body and thus the case should be thrown out. But that is not the standard. Thus, the issue on this case is quite simple. It is what controls the movant's burden on summary judgment.
You basically concede that she was not hit by the door, right, herself.
Not herself, Your Honor, that's correct. Critically, the door, as we know, is not visible in the video.
But that
so-
contradicts her deposition testimony, so what are we supposed to do with that?
It contradicts her deposition testimony, but it does not prevent the allegation from being proven that the door is what in
But it's
fact
just
caused her injury.
speculation. I mean, you don't have any proof of that.
Your Honor, a jury would be able to infer from the video itself that the door nevertheless caused her injury. We can see, and the plaintiff testified, that she's got a chair wedged underneath her arm. We cannot see whether the chair made contact with the door, whether the door made contact with the chair. And we thus cannot rule out that the door caused, albeit indirectly, the plaintiff to fall. My respected adversary contends that this is exactly the question, that the burden on summary judgment is controlled by the evidence, contending that if he can refute the statements that our client made at her deposition, then he is entitled to judgment as a matter of law. But he makes this argument without one iota of precedent in his briefs.
Well, I mean, when you're looking at the video and you don't question its authenticity, it's clear the door didn't hit your client. That's undisputed.
Yes.
The issue is after the fact, when you're confronted with the inconsistency between your deposition testimony and the video, which is clear, and one looking at the video could say that she arguably was overloaded by holding stuff in one hand and the chair in the other hand and maybe made a misstep going down the 6 flights of stairs to get out of the building. That's what it looked like to me, but I'm not a jury. But given that backdrop, the notion that the chair was hit by the door is really speculation. And when you're confronted with that kind of glaring inconsistency under this record, why do you think you should survive summary judgment?
Because a jury could make the inference that there was a dangerous condition there, and that this dangerous condition, to wit that the door closed too quickly. We submitted, also in the record, I believe page 276, a video showing the door closing in less than a second. It's entirely foreseeable.
It's more than the door just closing quickly. It's the door closing quickly and making contact with your client, right? And we know the door doesn't make contact with the client. Now the question is, does the door make contact with the chair? What's the evidence of that other than speculation?
The evidence of that is an inference that the jury can make. The jury can watch the video. The jury can see that she's got the chair wedged underneath her arm. It can see the evidence of the door closing very
Your client doesn't say that, does she?
That's correct. Our client, however, does, the record shows justification for these incorrect statements by the client. And a lay jury could very well appreciate and relate, to these statements. The door shut quickly. The video shows her looking forward. It shows her not looking behind her. She doesn't see what's exactly is pushing her down the stairs. She feels something push her down the stairs. She testified inconsistently with the video because she had not watched the video. It was a painful experience for her.
Did she need to see the video to know whether or not the door hit her in the back?
I'm sorry,
Or if
Your
it
Honor,
hit- Did she need to see the video to testify whether or not the door hit her in the back? That's what she said. The door hit me.
That's what she said. She based that on her experience in the past with the door closing very quickly. She was carrying this chair. It was wedged under her arm. She knows
But
something.
based on what happened that day, she should have known what happened that day, whether the door hit her or not.
Not necessarily, Your Honor. She wasn't looking behind her. She was looking directly in front of her. She was navigating the stairs.
So she wouldn't be able to feel the door hitting her.
She could feel something hitting her.
And what else other than the door would hit her?
The chair. The door, if the door hit the chair, as indicated by the cases in our briefs involving, for example, motor vehicle collisions, 3-car motor vehicle collisions, no direct contact is necessary between a causative mechanism and the individual who is injured in order to establish the causation.
She didn't say that the chair hit her. She said the door hit her.
That's correct, Your Honor.
Thank you, counsel. You have time in rebuttal.
Thank you.
You done? You done?
I think one thing that,
Please.
Daniel Heyman for the defendant respondent. I think what counsel is glossing over is the fact that the video shows Ms. Bonia standing on the top of the stairway for 5 or 6 seconds before she falls. So even if it's true that in her lifting up the door may have hit the chair, it basically, she has no evidence that the door closed quickly, which is the sine qua non. That's the presumed negligence, is allowing a door that closes too quickly for somebody to pass through. The video shows that she did pass through, and she stood at the top for about 5 or 6 seconds before she fell. She then picks up the chair in the crook of her arm and appears to.
I have to tell you, Counsel, I saw that video several times, and I don't think I ever thought that she was there for 5 or 6 seconds. But be that as it may, isn't that a jury question?
Isn't what a jury question, that it's 5 or 6?
Whether how long she was there and whether the door struck the chair.
Well, if the jury made an inference that the door struck the chair, what would they base that on? Well, there's no evidence to base that on. The sole evidence in this case is the plaintiff's testimony. And she testified that the door had hit her. That testimony.
This is counsel's theory, right? I mean,
whose theory?
It's plaintiff's counsel's theory that the door hit the chair, right?
Yes.
But he wasn't there.
Clearly not. I don't know how he would even propose that to a jury and offer any evidence as to that without the plaintiff coming up and impeaching her own deposition testimony. I just want to make one other point with respect to what counsel had said about that we didn't properly meet our burden because we didn't show that we didn't have notice of the condition, we didn't control the condition. If you look at the complaint is completely vague and ambiguous and not particular about what that condition could be. And the bill of particulars even goes backwards and doesn't even identify the door in question. All it says is that there was a dangerous condition. And I think what the video shows is there's no evidence that there was a dangerous condition. The only evidence of a dangerous condition was that the plaintiff claimed that the door closed instantly and threw her down the stairs and hit her back. And there's simply no evidence of that. Plaintiff had the ability to come back and in their reply and offer some evidence of a dangerous condition with the door. They offered nothing admissible, and the court below found that this was one of those cases where the video basically showed that plaintiff's testimony, which was the sole proof, was demonstrably false and incredible as a matter of law.
Thank you.
Your Honors, I would take issue with my respected adversary's references to any dangerous condition or absence of a dangerous condition, more to the point, insofar as they've never argued this point below. It was, again, part of their burden on summary judgment to show the absence of dangerous condition, to present, for example, an expert's review of the door to say that on the day in question the door was in perfectly functioning condition. They never did anything of that nature. In opposition, not in reply, but in opposition, we did provide, again, this video that I referenced before showing the door closing in less than 1 second. It's our position that a New York City jury who is very well versed in entering and exiting apartment buildings, whether they're laden with grocery bags, with child strollers, whatever the case might be, that they are going to be able to appreciate that a door closing as quickly as the door in the video linked at page 276 of the record will present a dangerous condition. Again, this is the only proof on this issue at all, whether for or against a dangerous condition, because again, my adversary failed to satisfy their burden on this point. If the court has no further questions, and I'll conclude briefly, if the court agrees with my respected adversary, then we lose the appeal, full stop. But if this court agrees with the premise that a movement for summary judgment has to disprove allegations and not challenge evidence that presents a credibility question, which is traditionally well within the province of a jury, and if this court agrees with the authority in our briefs that supports this premise, then the court should reverse the order on appeal and deny the defendant's motion.
Thank you very much, counsel.
Thank you.
Thank you both. Polymet Core Trading versus Traxxas.
Good afternoon. May it please the court, Patrick Lennon, Murphy and Phillips for the defendant appellant, Traxxas North America LLC.
The Supreme Court erred in denying Traxxas' motion to dismiss the complaint because it failed to recognize that the plaintiff, in this case, affirmatively pled that its claims were based on 3 specific contracts, all of which contained a 1-year time bar.
You can say a breach of a contract based upon other factors other than a contract. You recognize you don't need a written contract every time they have a contract. You agree with that, sir?
I do.
Okay, so when you sent your contracts to them, which had the 1-year statute of limitations, and it was never signed by the plaintiff, and my understanding is the contract is usually comes into life when you have both signatories to it, and then when there's email exchanges, and then there's invoices, and then you accept the product, and no complaint with the product, so they actually gave you what you wanted based on your negotiations. That's a contract, and you didn't pay for it. So that's a breach of contract. So how is that a problem here?
That's one way a contract can be formed, Your Honor, but this is a sale of goods governed by the UCC. And under the UCC, Section 2201, the statute of frauds, there's a merchant's exception. And the merchant's exception is well-established law in the state of New York, provides that if one party sends a confirmatory writing of a contract and the recipient of that has reason to know of what it is and fails to object to that writing within 10 days, the statute of frauds issue is gone. So that is a way that contracts...
Did they object, though, by proffering their own agreement?
I'm sorry, Your Honor, I didn't hear.
Did they object? Did the plaintiffs object by proffering their own agreement?
No, they did not. I mean, they say they did. In the record, there's an affidavit of a gentleman named Sem Gooden, who's the finance manager of the plaintiff. And what he claims is, we objected, we rejected, we never accepted, and so on. But he offers nothing to support what he's saying. The UCC requires that if there is an
Did they not offer their own form of the agreement, their own version of the agreement?
They say they did. There's nothing in the record to support that, Your Honor. Absolutely nothing. You can look through his affidavit and look through the exhibits that he annexed to his affidavit, and you will struggle to find any form of contract that they offer to say, this is what we sent. That's the record on this case.
Counsel, bring the microphone a little closer to you, please. The microphone a little closer to you so we can hear you better.
Sorry, Your Honor. That's the record on the case. That was the record in the case before the Supreme Court. There's nothing to establish that they ever sent another form. So all you have is a self-serving affidavit saying we sent a form every time they sent a contract, but he doesn't offer any contracts that they ever sent to Traxxas in relation to this deal. And so the point I was making about 2201.
But they do have an email, which is in the record at 81, where they refer to a contract that they are sending to your client?
Well, in the record at 81, Your Honor, yes, he says, find attached these contracts.
Right.
But the contracts had never been offered in the case. There's nothing to even indicate in these emails that there was something actually attached to these emails that he sent. There's nothing in the email body itself that says there's an attachment to it.
Then at 82, it says, our sales contract is enclosed.
Correct, but again, there's nothing in any of these emails that indicates there's an attachment, as would be normal with an email. And on top of that, they had the opportunity, number one, to have pled all this in the complaint, which they failed to do. In fact, they pled our contract forms by specific contract number. That's their claim. They're judicially stopped from denying that. But on top of that, they offered nothing in this affidavit to say, here are the contracts we sent. So you can say anything you want, but getting back to the point about rejecting or objecting to Traxxas' form contract that was sent, the UCC requires that that objection be in writing. And these emails that you're referring to in the record, starting on page 68, contain nothing indicating that they ever rejected or objected to the contract or any other terms in the contracts that Traxxas sent. In fact, there's specific negotiation over the quality specifications of the product, ending with the last email on page 68, where Polymet says, thank you and appreciate your mutual cooperation. After Traxxas is sent, here are the revised contracts that you asked for.
Weren't there subsequent emails regarding payment, which is a material term?
Whether payment is a material term?
No, were there, if I recall correctly, I think there were subsequent emails regarding payment, and that's a material term, right?
Payment can be a material term, but the emails just deal with the fact that they're claiming you haven't paid us. That has nothing to do with formation of the contract. The contract itself, the Traxxas contract, has a very specific payment requirement period. It's 60 days. That was never objected to either. And specifically, this one-year time bar provision that's in the contract is in boldface and says any claims of any nature whatsoever, whether they be contractual or non-contractual,
Thank you,
have to
counsel.
be
You have
brought
time
one
in
year.
rebuttal.
Thank you, Your Honor.
Please.
And may it please the court, my name is Andrea C. Melancon. I represent Polymet Corp., the appellate respondent. We respectfully request that this court affirm the lower court's correct ruling denying defendant appellant's motion.
Did you object to the contracts that were emailed to your client?
Yes, as this court clearly pointed out, let me tell you what the process is. We have been in relationship with Traxxas since 2016, and we've conducted business with them since 2016 the same way. They will call up one of our reps because we sell chrome or ferrochrome metals and powders. They will call up requesting what they would like to purchase, and then they would later send their purchase form. We would then respond either the next day or within a couple of days with our sales contract. And to understand what's discussed in actually both forms is where we're going to what they're purchasing, where we're going to send it, and generally by what time it will get to wherever. Generally, it was either Baltimore or Alabama, and so we would respond by our sales contract objecting and rejecting their purchase order. This was going on from 2016 up into this current case, 2021.
But the question is, where is that contract of yours responding to their contract? Where in the record can we find that?
See, unfortunately, we've done a lot of stuff. We've done mediation. It was shown in mediation. Traxxas never denies that we send them a sales contract. As you can see in the emails, you can see that there was a sales contract sent. So it's not in the record, but the point is that we're dealing with the pleadings. We can plead it. And so this motion to dismiss is premature. And so we plead it, and then we'll prove it within discovery.
Counsel, isn't there emails in the record from the defendant where they keep asking you, please sign their contracts?
And we do not.
Which clear that you're not. In other words, you're responding very much in a passive way rather than in an affirmative way, based on what you described. So in a sense, the invoices, the formation of a contract is, here's the invoice with a reference number or a contract number. As you said, with sending the product, they're acknowledging receipt of the project, they just refuse to pay. But a contract was formed in that context, correct?
Correct. And that's what we're saying. This is a simple case of goods sold, delivered, accepted, and not paid for. They never, nowhere in the record do they say they never received it.
And just to flesh out, because you acknowledge that your version of the sales contract isn't in the record, maybe it's the invoices, but your version, was that ever signed from your point of view? They didn't sign. So in other words, you're not signing theirs, they're not signing yours.
Correct.
And the parties are governed by their 5-year history here.
Correct. That they order it, we send it, they receive it, and then they pay their invoices. Usually it doesn't really get to a statement of account. In this instant case, it did, because for whatever reason, in 2021, at the beginning, they ordered 3 orders, which consisted of 5 shipments. When they received the shipments, that's when they paid the invoice. They paid for 2 of the shipments. 3 of the shipments weren't paid for, which resulted in the $1,059,000 invoices, and kept sending invoices. Months later, sometime in August, they send us a check for $94,000, saying where everything's paid for. And so we were taken aback, and then that's when we started sending the statement of accounts. We started sending out demand letters, because up until that point of August of 2021, they've always paid. There was never any issue between Polymet Corp and Traxxas. And so you are correct. Our performance created the contract. And we can plead whatever we would like to, well, not whatever we would like to plead. We pled breach of contract, quantum merit, unjust enrichment, because New York State is well established that you can plead in the alternative. And so that's what we did. We pled contract if you don't feel that it was a breach of contract, even though it is, and even governed by the UCC, it still created all of the performance created the contract. If you don't believe that, quantum merit, we proved within quantum merit that we received it, we sent it, it was ordered, they accepted it, they didn't pay for it. And then unjust enrichment, they received goods of $1 million, and we received nothing.
Thank you, counsel.
Thank you, Your Honor.
Your Honor, one thing that's in the record, and counsel just admitted, is that there's a relationship between these parties since 2016. And that establishes that Polymet had reason to know what Traxxas was sending when it said its purchase contract. And that purchase contract is not a purchase order, as counsel described it. It's a purchase contract. There's a big difference between those two things. And taking Your Honor's point about invoices as maybe constituting the contract, in the record, the invoices appear. You can look at one on page 89 of the record. Those invoices do not have all the material terms that one would find in a contract. The contract terms are in Traxxas's purchase order. Those invoices were sent months later, and that itself cannot constitute the contract. And Your Honor asked whether or not these contracts that they say they sent to Traxxas are in the record, and the response was they're not, and they never have been. So saying we object, saying we sent a contract is different than actually putting it in the record and saying, and here it is. But this record is barren of any evidence of those supposed contracts.
Well, it is a pleading motion. It's a 320, 3211.
Correct, and that's one of the most important things I'd like to emphasize as I conclude here. They pled these specific contracts that we've put in the record. Our contract numbers, and they pled those contracts, and it's replete throughout the complaint that they make reference to those contracts in every single count, including their non-contractual causes of action. And the important thing about that is that in this case, there is no dispute that there's a contract between the parties. And New York law is clear on this. When there's no dispute about the contract, or that the fact there is a contract, you cannot plead quantum merit, unjust enrichment, and account stated as another way of trying to recover on what is otherwise a vanilla breach of contract claim.
Well, if you claim that the statute of limitations expired, which is what your claim is by virtue of the language in the contract, then yes, maybe the cause of action for breach of contract and account stating goes out the window, but quantum merit would not, and then action would be timely under quantum merit.
Not on the
and independently for unjust enrichment.
Not on the language of this contract. If you take a careful look at the actual clause in this contract, which is in the record, in boldface capital letters, it's any claim of any nature against Traxxas is barred if it's not brought within 1 year. And that's what this case is about. They brought these claims more than 3 months after the 1 year time bar expired. Thank you, Your Honor.
Thank you, counsel. Thank you both. Kavano v. 237 Park. Please.
Good afternoon, Your Honors, and may it please the Court. Teresa Din, counsel for the defendant's appellants. In deciding to grant the third-party defendant's motion and denying our motion for summary judgment, seeking conditional judgment on our contractual indemnification claims, the lower court failed to address the applicable indemnification provision, which it was required to do. Had it done so, the lower court would have found that all 3 subsections of that indemnification provision, where all men agreed to indemnify my client's PMG and 237.
But counsel, you come up against the temporal limitations of the subcontract, the 88 weeks portion, or 88 months, I forget, but, and then the hours, the 7 a.m. to 3:30 p.m., and the accident happened outside of those temporal limitations. So how do you deal with that?
Your Honor, the indemnification provision does not require Allran to have been working on site at the time of the plaintiff's accident. The Allran witness admitted that they were still on site performing their scope of work as they were the only electrical subcontractor on site. So although their temporary lighting duties had already ceased, according to what Allran argues, they were still on site performing the rest of the scope of the work. And the indemnification provision provides that their indemnity obligations can be triggered merely by performance of the work, which the temporary lighting equipment was still on site to facilitate.
Thank you.
So, the contract called for them to provide temporary lighting from 7 a.m. to 3:30 p.m., correct?
Correct.
This incident occurred at 8:30 p.m., so it's outside the hours that they were to provide temporary lighting, correct?
Correct, Your Honor.
The contract was for 88 weeks, and it was dated in March, and when did it begin? March of 14, and it began sometime in late March of 14?
Yes, Your
And
Honor.
when you count the 88 weeks, the contract would have expired on the temporary lighting, would have expired prior to this incident taking place.
Correct, Your Honor. However, the indemnification provision, the language says performance of the work by the trade contractor. The trade contractor was hired not only to provide temporary lighting, they were hired to provide lighting power for the entire project. The Allran witness admitted, yes, we were still on site on the date of plaintiff's accident, performing the rest of our scope of work.
Was there an employee, an Allran employee at the site at the time that this incident took place?
No, Your Honor.
Were they somehow engaged providing lighting at that particular spot where this incident took place?
Well, it's the very lack of temporary lighting in the area where the plaintiff was injured that was the cause of the accident. So their equipment was supposed to be on and working at the time of the accident.
Was it their equipment or someone else's?
It was their equipment. They were shown the accident footage. They said, yes, those are my lamps.
Well, my understanding is that, A, your client had made it clear that Allran did not have to be there in the lobby at this particular time. Your client made clear that if he needed lighting, he would borrow one of their abandoned equipment or their light stand, halogen light stand, I think it was, if they needed it. But the focus here is whether they had some kind of duty to trigger the contractual indemnification clause. And while you're correct that Allran was there doing something else at some other part of the building, the focus here has to be what was their responsibility vis-a-vis the accident in the lobby here. So under those circumstances, given the contract or their duties ended after the 88-week period, my colleagues were basically asking, what was the duty here? Contractually, there was no duty here because they fulfilled it, and as conceded by your own client.
Your Honor, those are more arguments that address the common law indemnification and contribution claims between us and Allran, but the language of the indemnification provision is very specific. It says performance of the work. It doesn't limit the indemnification duties based upon whether Allran was there on site, whether they were still providing temporary lighting. It's clear it says performance of the work, and subsection...
Of any work, not of the temporary lighting, which is the subject of this contract?
That's right. The indemnification is very specific. It says performance of the work, and then subsection B also says any accident alleged to have happened in or about the place where Allran had equipment, personal property in the vicinity. The indemnification provides, subsection B says, Allran agreed to indemnify my clients if their equipment was in the vicinity of the plaintiff's accident.
Thank you, counsel. You have time in rebuttal.
Thank you.
May it please the court, Your Honor, Abe Reichik, Katz and Reichik for respondent, third-party defendant Allran. The contract had a limited scope, limited time period, limited
Your
provisions.
equipment was still there. You were doing work. So they're entitled to indemnification.
We not under this contract, we weren't. We weren't doing work under this contract. We weren't doing work in that area. We weren't there during those hours. If we were doing something else in some other part of the building under a different contract, council might bring an action under that contract. That's not what we're talking about. We're talking about this contract for temporary power and light for that particular location.
So your contract actually, in paragraph 31, actually describes the scope of work, which is what we're describing, the temporary lighting.
Correct.
And your friend is really referring to the general conditions under the indemnity provision. But we have to relate those general provisions of work that your adversary keeps referring to the actual scope of the work here, which is, like, if the accident happened while they were doing the temporary lighting and they didn't do it right, then arguably there would be a basis for contractual indemnification. Am I correct?
You are correct, Your Honor. Respectfully, there's a modifier. It says by reason of or as a result of the performance of the work. And that's the emphasis here. It has to result from the performance of the work. If someone takes an all-ran stand after it's gone and after it's done with this contract and goes ahead and does something with it, this provision is not triggered. There's no indemnification. There's no further questions. I'll rest on the rest of the brief.
Thank you, counsel.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court, Zachary Perisman for plaintiff respondent. I'm arguing solely on the discovery issue that I guess was brought into this appeal.
The subpoena of Christopher Davidson.
That's correct, Your Honor. Defense counsel did not bring that up in her argument, so I'll just try to be as brief as possible. The lower court
You were already on notice.
I'm sorry, Your Honor?
In other words, you're not challenging, are you challenging the quashing of the subpoena?
No, I am as a respondent.
Oh, okay,
So,
I'm sorry.
Plaintiff's position is that the lower court properly quashed.
They knew about it all along, and they shouldn't have waited until after the note of issue to seek this discovery, in effect.
Correct,
That's
Your
your
Honor.
position.
My position is that they knew about Mr. Davidson from the beginning of the case when they disclosed him as a witness in their own accident report, which had his full name, address, and phone number. They did not seek his deposition. Plaintiff mentioned him at his deposition twice. They did not seek his deposition. We disclosed him properly in discovery with his name and address as a witness. They didn't seek his deposition. They didn't move to vacate the note of issue within 20 days after it was filed. And then 6 weeks after summary judgment motions are filed and plaintiff presents his arguments in favor of partial liability, summary judgment, they serve this subpoena. Justice Bluth correctly quashed the subpoena and denied their motion for post-note of issue discovery because there were no unusual or unanticipated circumstances. We were not required to serve the affidavit of Mr. Davidson. All we were required to do was to properly disclose him as a witness during discovery, which we did. And it would be highly prejudicial, actually, right now to earlier when Justice Bluth made her decision and definitely now to allow the deposition because it would allow defendants to tailor their questioning based upon plaintiff's liability arguments, and it would disrupt the finality of the court's decision. If Your Honors don't have any further questions, I otherwise rest on my brief.
Thank you.
Thank you.
I'll go ahead and address plaintiff's arguments first. The only thing I would note for the court is that it would be extremely prejudicial to the defendants to force us to go to trial without having had a chance to cross-examine Mr. Davidson.
Why didn't you ask to depose him? You knew that he existed when this action commenced. And he mentioned, like counsel stated, he mentioned Mr. Davis at 373 in the record in his deposition. He mentioned everybody that was there by name.
He did, Your Honor, but we weren't aware that he was going to make all these statements about critical liability issues until we saw his affidavit attached to plaintiff's motion for summary judgment. And so that would be the unusual and unanticipated circumstance that he made all these substantial...
When a witness that you know is in the case makes a statement on a summary judgment motion, that's an unanticipated circumstance?
That's what we're arguing, Your Honor. And the case law cited by plaintiff doesn't address the extreme prejudice if we were not given an opportunity to cross-examine that witness on the statements made in his affidavit.
Thank you, counsel.
Can I say, sorry, one thing about
I'll give you 30 seconds.
Okay. The only thing I would say about that is that he addressed the only subsection 1, where Allred agreed to indemnify the defendants when when the claim arose out of the work, performance of the work by the trade contractor, but he did not address the other 2 subsections. It's our position that all 3 subsections were triggered under the facts of this case. Thank you.
Make that point in your brief. Thank you very much. Thank you all. Chopa, the ESRT. Please.
Good afternoon, Your Honors. May it please the court. My name is Michael Zhu. I'm appellate counsel to Morgan, Levine, and Dolan, attorneys of record for the plaintiffs Frank and Linda Chopa. The lower court's order should be...
You're seeking relief under Industrial Code 23-1.72. How does this plywood floor constitute dirt, debris, scattered tools, or materials and materials from sharp projections?
It's very easy, Judge Freeman. It's a tripping hazard. Clifford Chow, the representative from...
But a tripping hazard might give you common law, negligence theory, but it doesn't fit within this section. How does it fit within this section? That was Justice Friedman's question. How is it debris? How is it... It's obviously not a tool. So tell us how it fits within the industrial code section that you're relying on.
Well, any condition that would likely cause tripping is a condition that has to be...
That's not what it says, I don't think.
There may be other provisions of the industrial code that do what you're talking about, but this is a specifically tailored protection against debris, dirt.
Well, I would submit that the hole itself creates a slight elevation differential.
It creates a hazard. There's no question it creates a hazard. There's no question it certainly sounds like it's negligent to have used that sort of a piece of plywood or to have allowed that condition to develop. But don't you have to somehow, in some way, meet the terms of the industrial code provision that you rely upon?
I do, and I would submit that the items that are described within the regulation, the dirt and debris and scattered materials and materials, those are just examples of what tripping hazards are. It's not exclusive, so meaning that anything that rises to the level of a tripping hazard is a condition that needs to be...
Whether it be just, let's say, one tool, or one piece of wood, that would be sufficient to fall under this statute? Is that what you're saying?
Absolutely. Sure, Judge. I've won plenty of cases where you have
If you tripped on something, no matter what it might be, it would fall within the confines of this industrial code provision, because by virtue of the fact that you tripped, that means it's a tripping hazard, and that's what this means to cover. That's what you're saying.
Yes.
But that's not what this says.
But the dirt and debris are just examples that the Industrial Board has chosen to use, but that's not an exclusive.
Let's do it a little differently. Dirt and debris could be a pile of rocks, or demolition debris, as we understand it. Could be cables. I mean, the cases speak of what detritus at a construction site. We're focused here on plywood that was intentionally put down to protect the floor, but was defective because it had a hole in it and became a tripping hazard. You agree that there's something markedly different between a piece of plywood, and I'm not arguing for integral to the work. I'm just saying what it was doing here. It was intentionally put down, and it was a tripping hazard by the very nature of how it was physically formed or it existed at the time of the accident. How did, again, as they pointed out, how does that particular item fall within debris? It's not debris. It's not dirt. It certainly wasn't scattered. It's certainly not a sharp projection. And it's So how does it work?
It's interesting because in working on these cases, and there are other cases that we cited, more particularly Tompkins. It's a second department case. I'll concede that, but Tompkins involved a warped piece of masonite. It belonged there. It was placed there on the ground to protect the flooring underneath, but it was held to be defective, and this was before Basdaric. It was held to be defective because it was warped, and the warped nature.
Was it held to be a violation of Industrial Code 23-1.7?
1.7E.
It was held to be a violation of that.
Yes. Yeah. If you.
But that's the decision which the second department doesn't explain how it gets to that conclusion, right? It's a very brief decision. Am I recalling
Well,
it
it holds that the defendant failed to raise issues of fact as to whether the warped piece of plywood was integral to the work.
But anyhow, according to the way you read 23-1.72, what it should have said is the floor should be kept free of tripping hazards.
And it does, including dirt and debris and scattered materials. But just because
But counsel, but to get to integral to the work, don't you have to first establish a violation of the Industrial Code?
I do, yes.
Right?
And
So
I
you
have.
only get to integral to the work if you establish a violation of the Industrial Code.
I do, and I have, based on the tripping hazard under 1.7E2.
So you're saying, again, I know we've asked this, but I just want to make sure that I'm understanding you. Any tripping hazard is a violation of this Industrial Code that you allege here.
I would, well, a tripping hazard involving a piece of board that's on the floor.
Intentionally
yes,
placed there.
Intentionally placed, yeah. We have Giza versus New York City School Construction Authority. That said a warped piece of plywood.
Well, that was a triable issue of fact in that case. They didn't make a finding in the plaintiff's favor yet. And Ginza also raised the issue of whether it was integral to the work.
Right. But then I'll just rely. I'll rely on Tompkins. Tompkins versus Turner Construction, 2023, where the second department held that the plaintiff demonstrated his prima facie entitlement to judgment as a matter of law on the issue of liability, because quote, moving on, he fell over a tripping hazard in a passageway in the.
Oh, wait. That's a very different section, because passageway E1 does not have the description that we have in E2. E1 is broader because the passageway has greater traffic. And if you look at the language of E1, it says obstruction. So conceivably, plywood, the way this is put down here, could arguably constitute an obstruction. It is not E2, very different sections under the regulation, and you're moving under E2.
No, I mean, okay.
Well, it's not okay. That's a big difference.
Well, no, I understand. No, the point why I cited Tompkins was for the integral to the work. And Judge Friedman asked, well, if a sheet of plywood is not debris, I'm sorry. Judge Friedman asked
my questions were not premised on it being integral to the work. That wasn't my point. I can see that you can say that this was not integral to the work because it didn't have to be it didn't have to be a defective piece of plywood for the job. You could have had a better piece of plywood.
Right.
You have time in rebuttal, counsel. Thank you.
Thank you.
May it please the court, Nicholas Calabria, Amity Demirs McManus for ESRT 112 34th Street and Empire State Realty Trust, Inc. My clients have already won summary judgment on the Labor Law 200 claim, which essentially is what plaintiff is arguing in this case. If you look at the statute that he's going under, however, clearly the working areas, a plaintiff will have to establish that the section has been violated. He will have to show that there was an accumulation of dirt, debris, scattered tools and materials, or sharp projections. None of that is here in this case.
So it takes more than one. It's got to be an accumulation of.
Or no, it could be an accumulation of debris. If there was a pile of debris that he fell on, that would trigger the statute. However, none of that.
It's got to be debris, not a piece of plywood
Correct.
which was intentionally put down there.
100%
It may be a defective piece of plywood, but it's not something which you would characterize as debris under the plain meaning of the word.
Not after if there was, the testimony is it was placed there because The floor that they ripped up left the floor wobbly, and they put that there so people weren't tripping on it. What we're discussing here, either 200 versus 241.6, was something that Judge Garcia in his concurring opinion in Bazdarek clearly pointed out, saying, look, just a tripping hazard is not what the statute is regulating. It's certain types of accidents that the industrial code is written for.
Respectfully, they were really focused on D, not E1 and 2. Judge Garcia.
correct.
We
none
don't
of-
want to confuse
But none of-
slipping and different. It's a different. The focus is not to be so broad-based. That's what really Justice Garcia was saying.
And he was concerned about that because of a situation where someone is trying to, where we have negligence case. He still has the negligence case against American, the GC. That's still in the case. But I'm the owner. I had nothing to do with the construction accident. I was not negligent. I was not supervising or controlling. The 200 was dismissed. And if there's no 241.6 violation, I'm out of this case. And I believe, based on the concurring opinion and what your honors have brought up, none of the specific types of accidents is in this case. 107E2 is simply not applicable. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. Artie Venti for Respondent SNV. I confer with counsel for ESRT and his arguments that the specific industrial code is not applicable to this matter. However, if Your Honors do change your mind, if Your Honors do decide that there is an integral to work component to this, I just want to point out that the work performed by Mr. Chiappa was in the work of protection and in setting up the work area, and the plywood would have been
In the face of
integral to that
Bazdarek, you can't really make an integral to the work argument here because, yes, it was integral to the work, but it's not integral to the work to take a defective piece of plywood. So that is not a basis for holding in your favor. Whether this provision applies, whether this provision has been violated is a separate story, a separate issue. But it can't be, from it becomes apparent that just like you couldn't have a piece of plastic covering an escalator, you can't have a bad piece of plywood covering the floor.
Understood.
That, in terms of being integral to the, it's not integral to the work to have defective plywood on the floor. That's my point.
I would agree with that. However, in applying Balsdarek, this would be similar as if Mr. Balsdarek was actually putting on in the performance of the protective work. He was injured while he was painting from the protection.
Yeah, that's not a distinction I find particularly compelling. You got to prepare to do your work. That's part of the work, I think. So I don't think that's such a strong argument for you, counsel, personally.
But Bazdarek doesn't deal with the same provision that we're faced with here.
Yeah.
I agree, Your Honor.
Anything you'd like to add?
That's all. Thank you.
No questions? Okay, thank you.
I understand the court's position, and unless the court has any further questions, I'll waive my rebuttal time.
Thank you, counsel. Thank you all. Legal Aid Society versus Records Access Officer.
Good afternoon, Mackenzie Fillo for the NYPD. This court should reverse because Supreme Court committed a legal error here. FOIL allows an agency to deny requests that are too big to be handled in-house and cannot be performed by an outside vendor, and that is the case here.
Was that proven by Mr. Murtaugh's testimony and whatever else happened at the hearing?
It certainly was. In fact, Supreme Court agreed that the request was extremely voluminous. It's 165,000 pages. It can hardly be disputed that it's voluminous. And the Supreme Court agreed that each page need to be reviewed by a lawyer. There's just no support for any contrary decision. The Supreme Court seemed to
But
think...
a lot of those pages, doesn't the record make clear, a lot of those pages are redundant pages and also consist of boilerplate that's required by various state and city regulations?
Not at all. Actually, it's not just we have two witnesses that provided testimony, one in an affidavit and one at a hearing. And the affidavit is from our attorney who explained that he went through one of the filing cabinets and made sure there were no duplicates and counted every single page. And it was 7,500 pages just in that one filing cabinet, and there are 22 filing cabinets. Now, certainly some, contracts do contain boilerplate language, but still each page will need to be reviewed by an attorney to make sure that there's nothing that needs to be redacted on that page. And the fact that some of it's boilerplate doesn't mean that that can be done so easily.
Also, the focus is not really the volume. The focus is whether it's unduly burdensome, right?
Right, but the volume is what makes it unduly burdensome.
Well, that's a consideration.
Certainly, and if it was just 165,000 pages and no redactions were required, we could hire someone to make these copies. It would be no big deal. I mean, there might be some objection. I don't know what it would be. It wouldn't be this objection.
So your argument is that it's too burdensome, and it's too burdensome because within these 165,000 pages, is it?
Yes.
There are materials which you are entitled or required to redact, and therefore each of these pages has to be looked at by someone on the NYPD staff to make a determination whether this can be released or not.
That's exactly right. And in fact, our attorney gave an affidavit saying that he dealt with 15 of the contracts, and it took him 3 weeks, and that was just for the initial review, and it still had to then go to his supervisor. And from the amount of time that it took with those 15 documents, he extrapolated that he thought it would take over a year just for his initial review, and then his supervisor has to check his work. I mean,
We know how much this burdensomeness is caused by the fact that it's not digitally stored. These are all hard copies, right?
I believe it's...
So are we creating a perverse incentive for agencies of any kind by saying, gee, if you have too many hard copies, maybe you're right, it's going to be unnecessary, or it would meet the burdensomeness standard?
I don't think so, not at all, because I think that actually it would take the same amount of time to do the work even if they were electronically stored, and they aren't being stored in paper copies to evade some sort of obligation.
Was there a reason it's stored in paper copies as opposed to
Yes,
electronically?
for security concerns, because that way they can't be hacked.
There's a concern that it could be hacked if you
That's
didn't have
exactly
hard
right.
copies and you had it
Yes.
stored digitally?
These are so secret that most employees of NYPD don't even have access to them. We're not talking about something that can just be shown to anyone. There's a
So
lot
in
of...
that regard, does FOIL allow you to redact these documents like line by line, or is it that you claim an exception and you withhold the document?
Well, the redactions can be made so that we could disclose the document. It's the amount of time that would be required to do all of those redactions is what makes it unduly burdensome.
Your office did disclose some of these documents already to the comptroller's office.
The comptroller was never given unredacted copies. He was given redacted copies. I think he was maybe shown at times unredacted copies, but he was never given an unredacted copy. He then released some redacted copies, which Legal Aid has. And so to the extent that they have those documents, that should provide them with a lot of the information that they seek. But their request here is much broader than that. They're requesting all kinds of documents, any document related to these contracts and the specs program.
Counsel, the remedy that, well, I shouldn't say remedy, but what the Supreme Court ruled in terms of giving you extra time to comply, doesn't that resolve the problem?
No, because the statute doesn't require us to take that amount of time. That's the whole problem. This would take over a year of just for the first level employee to do the work, and then who knows how long for his supervisor to double check everything. Because of the sensitivity of the data, we would have to do.
How many levels of employees would need to look at this?
Probably just two.
Just two?
The line attorney and then his supervisor.
Some of these documents, do you have contractual obligations not to disclose them?
Yes, that's another thing. A lot of the documents
Those
are.
who developed the whatever the
Right.
process was that is reflected in the contract?
Right, these contracts, some of them were subject to non-disclosure agreements, so
If that's the case, and I don't doubt that it is, wouldn't that be easy to ascertain which ones you cannot disclose because you will need waivers?
well, that would be one of the things that the attorney would determine when going through every single page of the 165,000
You would have
pages.
to go through every single page to determine which ones have required waivers?
Well, to look at each document to see if it's subject to a non-disclosure agreement. I mean,
You mean
they'd
to look
have-
at each contract?
Right.
I'm
Yes.
assuming they're not 175,000 contracts.
Each one is more than one page probably. So I don't know exactly how many contracts. We would have to go through all the pages in the first instance to determine that.
Thank you. You have time to
Thank
rebuttal.
you.
May it please the court, Duncan Hosey of Orrick, Harrington, and Sutcliffe on behalf of the Legal Aid Society. This is an important and straightforward case. For years, the NYPD has worked to block legal aid from getting access to records that are critically important to our clients and are of public import to the legal system.
Also, it does sound that if you take NYPD's position at face value, that it would take at least these two attorneys, maybe an additional 3, and it would take them years to review this. Doesn't that make the standard of the case for being unduly burdensome?
Those questions were addressed at the evidentiary hearing, where NYPD failed to meet their burden to establish that. They produced one witness, Mr. Murtaugh. Mr. Murtaugh made that conclusion about it
But
taking
he's the
years.
witness who's in charge of this, isn't he?
He is, but he had an obligation to speak with specificity and particularity to why it would take years. There's actually a contradiction between what Mr. Murtaugh said and what my friend on the other side said today. He said that it would take, quote unquote, years. I think it would take years. He didn't say how many years. He didn't talk about how he reached that conclusion.
But
Today we heard it would take
we
over
can
a
all
year.
agree, can we not, that 165,000 documents pages of documents is a lot of material to go through. I mean, it's not like a big leap to say that's quite burdensome.
The 165,000 figure is an estimate the NYPD has provided. Courts in the First Department have upheld in Article 78 proceedings, turning over similar amounts of documents.
Mr. Murtaugh testified to that, did he not?
He testified to it, but again—
Is there any reason not to credit that testimony?
Justice Bluth, in a case decided last month, I think it's an instructive example, so I'll talk about it. She ordered in an Article 78 proceeding the NYPD to turn over 161,000 documents, and she dealt with the same arguments that NYPD made in this case, in which the NYPD argued that they were burdens. She said there was not a specific explanation of why, that you can't just rest on conclusory, self-serving statements of one witness who's employed by the NYPD. You have to do an explanation
How does this
based
case,
on the record.
you know, speaking of large volumes of documents, how does this case differ from matter of the Jewish press? I know you try to distinguish it in your brief, but unpack that for me.
The matter of Jewish press case, there are 2 of them. I'm going to talk about the one from 2022 because I think that's the one in the reply brief, but I'm happy to speak about both of them. This matter of Jewish press case in the reply brief, there was a determination in that case that the government agency couldn't work with an outside vendor. In this case, the evidentiary hearing was held for that specific purpose. That's why legal aid asked to have it. That's in the record at R8. A significant portion of Mr. Murtaugh's testimony was dealing with the fact that NYPD couldn't have an outside vendor, and that conclusion was rejected. It's critically important to draw on that Jewish press case that my friend on the other side invokes, because there was an amendment to FOIL in 2008, the 89 3A amendment, in which the New York State Legislature was dealing with the fact that we live in a different age from when FOIL was created, and they didn't want the government in these burdensomeness allegations to rest on the fact that we have a lot of documents, given the fact that there's been digitization, that it's much easier to disclose documents.
Are you asking us to find that the NYPD should bring in an outside agency to review these documents?
It was NYPD's burden to demonstrate that they could not bring out an outside agency, and they failed to establish that. So that's on their end to prove. It's not on legal aid's obligation to demonstrate how NYPD complies with
Well, when they say that these are materials which they cannot turn over to an outside agency to make a determination about, what's the invalidity in that argument?
There was an obligation at the evidentiary hearing for Mr. Murtaugh to provide evidence for that. If you look at the record at R28, when asked
What evidence would you have required them to bring in on that?
There are many cases in which NYPD has successfully been able
What
to
evidence would you have
So the-
required them to bring in on this case?
In the Jewish press case that I was talking about with one of your colleagues previously, NYPD was able to bring specific evidence about why there was confidentiality concerns with working with an outside vendor. They were not able to point to those arguments in this case, and there's no factual basis for them to do so. We're talking about a lot of documents that are boilerplate that are already in the public record. There are a lot of Byzantine requirements that the city of New York places on contractors who do business with the state.
Well,
And
you're
Iran
not
and Vasser
interested.
disclosure-
You're not interested in the documents that are already in the public record because you have them. So that's not why you brought this FOIL request.
Correct.
To get documents that are in the public record.
I bring that up because NYPD points to the 165,000 figure to make this argument about burdensomeness, and we want to note that in that document there are many records that have already been disclosed to the public, and so to the degree there is a burden on the government agency, it's much lower. But my colleague on the other side incorrectly stated the standard, and I want to state that clearly. The question is not whether they're voluminous documents. Courts in New York regularly order public agencies to turn over vast samples of documents. The question is an undue burden. The Supreme Court in this case correctly dealt with the legal standard, and that's what we think this court should do, is affirm the Supreme Court from recognizing that it's not...
You know, they did order a remedy, which Justice Rodriguez talked about, or he did, the trial judge. Now, did he have the power to do that, to have the disclosure go on for an undefined period of time, and also the NYPD's its best efforts to comply with the production? Like, is that allowed, that kind of remedy under
We
Article
believe that's
78?
in the trial court's discretion. The NYPD proposed a rolling production schedule, so that got introduced into the case from the NYPD's position. The Supreme Court in this case is not the first trial court in an Article 78 proceeding to have a rolling production schedule. It's a reflection of the type of documents here. We don't think it would be fair to weaponize the Supreme Court's effort to work with the NYPD against legal aid in this case.
Also, if Supreme Court had found and agreed with NYPD that the production here will be unduly burdensome, wouldn't the inquiry then end for Supreme Court?
Correct, but they didn't make that conclusion. The Supreme Court found it wasn't unduly burdensome in this case.
And
that's
we're not bound by Supreme Court's conclusion, isn't that correct?
You're not bound by it, but I would point to the third case invoked by the counsel on the other side in the reply brief, in which they changed their position on the standard of review, the Northern Westchester Park Association versus Bedford case. It talked about when this court is sitting in the appellate posture, it has to take into consideration the fact that the trial court is closer to evaluating the testimony of the witness. This case, the linchpin of it, by NYPD's own terms, is the credibility of their sole witness, Mr. Murtaugh. They had an obligation to do more to establish their burden. It's not legal aid's burden. They failed to meet it.
Again, you come down to their sole witness. They brought in a witness who's in charge of this. It seems like that's a pretty good witness to bring in on the subject.
Pardon me?
I say you challenge their bringing in Mr. Murtaugh. They brought in a witness who is in charge of this, so it seems like that's a pretty good witness for them to bring into court.
It's not about who they bring in, but what the witness says. At the end of the day, the substance of what Mr. Murtaugh said failed to meet the relevant standards, and it was their burden again, not legal aid's. Thank you.
Thank you very much, counsel.
The NYPD proposed a rolling production schedule.
I'm not sure, actually. That wasn't really something.
That's interesting, because if that's the case, that undercuts your unduly burdensome argument, doesn't it?
Not at all. We don't.
Doesn't? You're saying if you give us a rolling schedule, we could produce it. I suppose that's what you're telling the court if that's what you're proposing.
I'm not sure if we said that specifically. This wasn't briefed, so it's sort of, I'm not sure that it's properly before the court, but.
That's another question. Well, I'm going to take a look.
Yes, please, thank you. The point, though, is that of course, if we had unlimited resources and we could take forever and we could do this. This can be done. It would just take forever. That is why we don't have to do it under the law. And I would like to just finally note, the idea that we can outsource this work is kind of absurd. These documents are so secret that most NYPD employees don't have access. The statute does not.
So why didn't you seek an exemption? Why didn't you seek a total exemption for all this?
We did. We said we don't have to produce it because it would create an undue burden, and we're here making that same argument again.
No, that's a very different argument. If you believe that you're compromising security aspects, because a lot of there was sensitive information based on the relationships and contracts involving terrorism, measures, et cetera, et cetera. I'm not going into that, but
sure.
So why didn't you just come in there and say, there's an exemption for this. We can't risk this. None of this should be forthcoming.
Well, it's not the whole document. It's just certain pieces of information in each document. So that's what can be redacted.
It wouldn't cover everything.
Exactly. Like the boilerplate parts of the contract, that can obviously be released. Is only certain parts of each document that might have to be redacted. And deciding what has to be redacted for security purposes is something that NYPD has to do for itself.
Your colleague attacked the evidentiary basis of your application. Do you have anything to say about that?
Yes, I'd say that, as you noted yourself, our witness is the one who would do the work. There's no reason, he was subject to cross-examination. Nothing that he said was disputed, and the Supreme Court credited what he said. He said, this is a ton of papers, and it needs to be reviewed by a lawyer. The Supreme Court seemed confused about the law. The court seemed to think that there was no exemption for undue burden, but there is, and this court should correct the error. Thank you.
Both. Our final case is People versus Kevin R.
Good afternoon, Your Honors. On behalf of Appellant Kevin R., the Legal Aid Society by Andrew Alexander. Your Honor, the appellant is requesting that the surcharge and fee in this case totaling $325 be vacated or be remitted to the appellant under CPL 420.35 2-A. A court may waive the surcharge or fees in particular circumstances, that being the defendant's age. Here, Kevin R. was 18 years of age at the time of the offense.
And the people don't object to this remedy, correct?
No, they don't raise any objections. I could continue or answer any questions that the panel may have.
No, but good for you for hanging in there for your client until the very end.
Of course.
Thank you.
Thank you.